Section 3D by the Patent Office, spike in the application by the Patent Office. The Patent Office probably was emboldened, or it became more courageous in its application. We noted that a decision of the Supreme Court setting things in the right direction can have a substantial impact on things that happen at the ground level. Now, this is a list of the grounds that were used. I will not get into it, but the last column is important, Section 3. Section 3 and D is one of those 15 objections to exceptions to patentability that you can have. One thing which we noticed that Section 3D was rarely used separately. In most cases, it was a combination. Combination with 3I, which talks about methods of treatment, and a combination with 3E. 3E is where you combine substances together to make combinations. So we found that 3D works well in combination. Now, what this means, 3D works well in combination and not in isolation, and 3D introduces a comparative yardstick. It makes the patent office ask the applicant to compare the new efficacy or the alleged efficacy with the efficacy of the drug that is already known. So there is some kind of a comparison between what was known and what has been found. There is a similar comparative yardstick which we introduced in the definition of inventive step. So that's why if some country wants to incorporate 3D, I would strongly recommend you also need to look at your inventive step, because these things work in tandem. So the new definition said that you had to demonstrate technical advance over existing knowledge. So there again, you can see that the applicant is made to do this comparison. So in conclusion, 3D works well if there is a support system that can help 3D to work well. Couple of things to note. One, there should be an obligation on the applicant to disclose the status of foreign applications. In India, we have that. So if the applicant fails to disclose the status of foreign applications filed elsewhere, it amounts to a misconduct. So it's preferable to have such a provision. Then when you introduce a 3D-like provision, it is also preferable to have a heightened standard of patentability by looking at your inventive step requirement. This automatically introduces enhanced disclosure standards, because once you ask the applicant to compare the prior art, which is a dangerous thing to do because it could be used against them, you are essentially enhancing the disclosure standards in patents. And finally, this could also lead to cooperation between patent offices. WIPO has many schemes on how patent offices can cooperate. There could be deference to patent office decisions from certain jurisdictions. They could be, but all this cooperation will work well if countries have the same kind of legal provisions in their patent law system. Thank you so much.
Thank you, Feroz. And next speaker, Tahir Amin from I-MAK. The second presentation, so I skip the
bio. Okay, I'm hopefully going to be very quick because some of it will be repetitive from what other people have said. I'm going to look at this from a more practice-based point of view. How patent oppositions assist patent examination. Feroz has pointed out how in India they have contributed to the improvement in examination, but the Indian Patent Office has done a largely proactive role in rejecting patents. That's not the case in every country, but even within India, I think one of the things that we discovered when we did a lot of the oppositions was to highlight to the Indian Patent Office certain techniques that companies use to try and work their way around examinations or patent oppositions. One of those being the refiling of divisional applications, and this is something that happens in a number of countries. Particularly if you look at the United States, there's a theory that you can never get a patent rejected because there's continuation applications and so forth. So from a practice point of view, by doing oppositions or challenges or even just monitoring how examination is happening, you're able to inform the system, the administrators of the system, where the flaws are. That can also not only help improve examination, it can also lead to policy reform. It can also try and change rules and practice guidelines. So this is why oppositions are important. It's because it's okay having laws on the books, as I said in my previous presentation. But if you're not involved in a system, and as somebody who practiced as a corporate attorney, who used to spend millions of dollars of my clients' money creating the law, it's not, you can't stop at just writing a law. You have to be in it. You have to work within it, and you have to redefine it. Because the patent laws today just didn't fall out of the sky and just end up as they're defined today. That's years and years and years of lobbying by pharmaceutical lawyers or by other lawyers in other industries creating the ground that they want. And this is why we have to do the same thing. It's a long game. It's not going to happen tomorrow, and you have to keep working at it. And slowly, we're seeing some changes in different places. Maybe they're only small, but that's how change happens. So it's important to be a part of the practice. And also, examiners, if you start highlighting the discrepancies in their examination, or you file an opposition, like for example in the work we're doing in the US, a number of things that we found was many examiners actually often don't apply a criteria of obviousness or inventive step. They'll simply apply a novelty standard, and then they'll say, yeah, you know, the patent's worthy of a grant. And they fail to apply an obviousness standard, which is the other criteria that you must apply. And so when you do an opposition, whether it be post-grant or even pre-grant, you can actually almost correct the examiner and show to him or her that you've forgotten to apply this standard. Or what they may do even, they may conflate novelty with inventive step or obviousness. And this is one of the fundamental problems of examiners, is they're not lawyers. They are actually technical people. They are either engineers or chemists. And they have a limited language of the law. And when you're put in front of lawyers, as we do, as I did as a corporate lawyer, we're great at changing the goalposts. We take the examiner over here, we'll take him over here or her over here, and eventually the examiner gets confused as to what the argument is. And eventually they'll grant. You see this happening at the EPO all the time. The examiner will reject, and eventually they keep changing the arguments and changing the goalposts. So it's up to us, and this is why I was talking about why there needs to be a public participation in the system, is to keep the vigilance and keep examiners on their toes. And eventually, through practice, through continuous repetition, examiners might say, well, I don't want to be the one who's granting patents when I shouldn't be. And so you start to change your behavior. So this is all behavioral change. And hopefully, the knock-on effect will be that in future, they will change how they examine certain categories of applications. So for example, whether it be a crystalline form or redefining obviousness and inventive step, I think which is one of the largest goals of the work that we're trying to achieve in the United States. Because if you look at it, the standard of obviousness in the United States is virtually non-existent. And that is influencing how other countries are applying it. It's pretty much a diluted version of novelty. And no wonder many patents are being granted. And this can then lead to new precedents and reform, which is the overarching goal of why we do this work and why we're trying to change examination systems. Because ultimately, we can't challenge every patent. And we want the examiners to actually do the job for us, such as the way Feroz was saying in his presentation in India. And it's only by being involved in the system can you start trying to erode the practices. And finally, it's about maintaining a public voice in the patent system. I firmly believe that you can write the greatest laws, you can do all these other things, but if you're not playing the game, then you're not going to win. You've got to have a ticket. And only by having a ticket can you really change how this works. So that's it. Thank you.
Thank you, Tahir. It was really interesting. And the next presentation about the role of Ministry of Health, and I invite Pedro Villardi from ABIA, Brazil.
Hello everyone, good afternoon again. So this is a very good question. Should the Ministry of Health have a role in the patent examination process. I'm telling you that my answer is yes, and I'm trying to explain why. In Brazil, we have or had, not really sure, the envisaged prior consent mechanism, and what it is a two-step examination of pharmaceutical applications. And I want to focus on this. It's a two-step, because during many of criticisms, people say, no, it's a double examination. No, it's not a double examination. And our example, and I want to refer also to capacity building, and you have to create metaphors, is that when you go to the airport, is it just one security check that you go through? Because it's a really big deal, security in airports, right? So you have to get your things to the X-ray, and you have to go get yourself through the X-ray. So the patent office may be the machine that your things go through, and the Anvisa can be the other machine that you go through. It's a really big deal to grant pharmaceutical patent applications. So you have to, it's a good idea to have a two-step examination. Another example is airplane pilots. There can never be only one guy in the cabin. There's always have to be two. It's the 4-eye technique. And that's the same here too, it's the 4-eye technique. And the structure in 2001, when the prior consent was set, Anvisa didn't have the expertise to do so. So they built that expertise. They created this coordination of intellectual property, and they built the capacity to really examine the patent applications. And I think that, don't know, Tahir, perhaps the lawyers can deceive some of the patent examinators, but in the end of the day, you really have to know what is written there. Perhaps the arguments go there or there, but when it comes to a chemical formula, the Anvisa had really a great capacity to look at it and say, no, this is an inventive step, because they've been on the laboratory and working on that and say, okay, this is an inventive step. This is not in the prior art. And in the motivation, why should have been the participation of the Ministry of Health in the patent examination processes? The motivation was a joint work between the Patent Office and Anvisa to give Brazil the best technical capacity as possible, and to ensure that only the merited patents were to be granted. And of course, it complies with the international rules, the TRIPS Council decisions, and the Article 8 of the TRIPS Agreement. And what is the relevance of this mechanism? Because it avoids consequences of public health of an undeserved granting patent, as we have seen example for Herman was saying, the Argentinian guidelines that rejects 95% of the patent applications. It was not the case of Anvisa's prior consent, it was more like 25%. But still, we think that it's a great difference from having another 25% of granted applications. And how? It's exactly what we have been talking about here, by guaranteeing the strict interpretation of the patentability criteria. It's not, for instance, okay, a combination of two drugs, yeah, that's very difficult to do, that's grant that patent. No, the combination of two drugs may be obvious for a technical person in the subject, so this should not be granted. That's how it goes. But since its inception in 2001, Anvisa's prior consent have been under attack. And the results, after 15 years, they're very positive, 16 now, but Anvisa has rejected over 400 patent applications, and 40% of the granted patent applications had to change to comply with the demands, such as improve clarity and reduce scope before being granted. Going fast, I'm sorry. What was the fragility explored by pharma? Why it has always been under attack? The Brazilian law that the Brazilian article that put the Anvisa's prior consent in the IP Brazilian law says that the granting of patent for pharmaceutical products and processes shall depend on the prior consent of the Anvisa. This is a little bit vague. What is shall depend? Well, for someone that's well-intended, it shall depend must mean to examine the patent application. If it doesn't mean that, it doesn't make sense to depend on an agency. And, but this was a weekend explored by the big pharma and even by the Brazilian Patent Office, which was always against having his monopoly over the patent applications stalled by the participation of Anvisa, and very much aligned with the pharmaceutical corporations. And so during the patent law reform processes, and Marcela worked a lot on that, we came up with an ideal language of this article, what it should be to really reflect the role that Anvisa has. The Anvisa's prior consent referred in the capture of this article shall analyze the patentability criteria, novelty, inventive step, industrial application, and other necessary conditions and criteria for the granting of a patent given by this law. So this leaves no doubt that the patentability criteria should be examined. And this lack of clarity that the Anvisa should examine the patentability criteria was really the Achilles heels, that's all, of the Anvisa's prior consent. So from 2001 to 2011, almost 10 years, it was micro-litigation. So whenever Anvisa rejected a patent for a given drug, the company went to the courts and challenged that decision. And eventually they won, but it was a more 50-50 basis case. And it was very hard to follow because you have, to keep track of every Anvisa's decision, and it was not the most transparent processes. This is a critique we have. But from 2011 on, the ground has shifted very much. And this is because there was this administrative level attack from the big pharma that pushed the Brazilian General Attorney Office, perhaps. Is that so, Marcela? General Attorney Office, AGU? Yes, thank you. Opinion that he issued that Anvisa should only take a look at the threats to the public health in a patent examination process. So perhaps only one patent examiner here, and that the fair question, is it possible to look at threats to public health in a patent application? It is not. It's information that is just not there because it's not supposed to be there. Other information is supposed to be there, and the information that are there is supposed to be looked by Anvisa. But this opinion created a chaos, and in my opinion, an intended chaos that really derailed the process from this moment on. Because the micro-litigation that was a 50-50 ratio, either Anvisa win or the company won, based on the opinion of the General Attorney Office, the companies started to win almost everything. So really undermined Anvisa's capacity to reject the patent application. And 2015, after having these several defeats of Anvisa injustice, the Interpharma files this judicial case, this collective action, that really puts Anvisa, hanging by very few. So we started to drop the case campaign. I forgot to mention that in 2011, when there was this opinion, we denounced this opinion to the UN Right to Health Rapporteur. We did press work and political pressure that allowed Anvisa to maintain its role from 2011 to 2014-15. When Interpharma filed the judicial case, we came up with the Drop the Case campaign. We filed an amicus curiae brief. We articulated with the Federal Prosecution Office to get into the process because they were not being listened. And they did, and quoting in a very good way, the high-level panel saying that we have to have strict criteria for patent examination. Nevertheless, that didn't work because there was another forum shifting, and the pharma went to the presidential office, and he issued a decree saying that Anvisa should have, tangential participation, that the opinion by Anvisa could be or could be not considered by the Brazilian Patent Office. So I think that now our pre-granted position worth as much as Anvisa's opinion on the process. And now in 2017, it's another step. Perhaps we can have automatic approval of all patent applications in Brazil which will get us close to South Africa reality. So the conclusion is that the Brazilian experience reveals that public health authorities need to follow up, and it's very healthy that they do, the patent application processes of essential drugs and raise their voice on the impact of undeserved patent applications may have in public programs. Anvisa works in the technical level, and its performance highlights how the patent applications are failing to meet fundamental criteria. You remember that 40% of the patent applications had to be changed to be granted. And they sound the alarm on low-quality patent applications, reinforce the need for stricter examination, as the Argentinian case shows, 95% of rejection. So the Ministry of Health participation in the patent examination is a way to ensure that a human rights-based approach is incorporated in this field, historically more close to the private sector, lawyers, sorry to hear, and ministries and trade and industry. Thank you.
Thank you, Pedro. It was really interesting. It sounds like war, and I hope you will win. So now we will talk about patent examination from patent office representatives. And first of all, I invite Mounsif. Elafia is currently the director of the patent department within the Moroccan Office of Industrial and Commercial Property, a post he has held since 2011. Elafia joined the Moroccan Office of Industrial and Commercial Property in 2001, and he has a degree from the Higher National School of Electricity and Mechanics. And in 2015, he earned a diploma in industrial property law at the Center of International Intellectual Property Studies in Strasbourg, France. Elafia is a husband and father of 2 children.
Ok. Merci beaucoup. Tout d'abord, j'aimerais quand même dire 2 mots. Je tiens absolument à les dire avant de commencer proprement ma présentation. Tout d'abord, remercier très vivement ITPC d'avoir pensé à associer l'OMPIC à ce forum. Je pense que c'est la première fois que l'OMPIC assiste à ce forum de discussion. Pour moi, personnellement, c'est la première fois. Et je vous avoue que je ne regrette pas d'avoir fait le déplacement parce que j'ai appris beaucoup de choses et j'ai suivi avec beaucoup d'intérêt les interventions des uns et des autres qui sont convaincus par leur cause, qui est une cause, à mon sens, très noble. Donc je ne regrette pas le fait d'avoir fait le déplacement, malgré des soucis de voiture en faisant l'autoroute entre Casablanca et Marrakech très tôt ce matin. Ça, c'est le premier point. Le deuxième point, c'est justement, je suis passé par des situations de stress ce matin, notamment au début. Et c'est à cause, justement, je me demandais, est-ce que je vais remporter le titre du grand méchant de la journée, parce que tout le monde parle de l'accès aux médicaments et un peu parle négativement des brevets d'invention, et moi je suis là pour un peu parler du système des brevets d'invention en général et surtout le système marocain des brevets d'invention. Mais cette situation de stress s'est un peu dissipée petit à petit en suivant avec beaucoup d'intérêt les interventions des uns et des autres qui étaient des interventions pertinentes, sérieuses, profondes, mais également dans la bonne humeur. Donc ça m'a un peu déstressé. Et voilà, donc je tenais absolument quand même à dire ceci. Et je vais passer à la présentation sur le système marocain des brevets d'invention. Donc la thématique, c'est justement comment éviter d'octroyer des brevets que vous avez appelés bad patents. Et cette question, si vous voulez, on s'est préoccupé à l'OMPIC depuis une dizaine d'années à ces mêmes préoccupations. On s'est posé les mêmes questions en quelque sorte. Et si vous voulez, 2 niveaux de réflexion. La première question qu'on s'est posée, c'est comment renforcer le niveau de sécurité juridique des brevets délivrés par l'Office marocain de la propriété industrielle et commerciale. Et comment délivrer des brevets solides et de bonne qualité. Délivrer des brevets pour des inventions qui ont le mérite. Et de l'autre côté, si à un moment donné on a délivré un brevet justement qui a le mérite d'exister, comment équilibrer entre les droits des déposants et entre les droits des autres. Donc si vous voulez, on doit faire ceci par étapes. L'étape première, c'est de pouvoir délivrer un brevet qui a le mérite, mais une fois ce brevet est là, il existe, à ce moment-là, trouver les mécanismes, les moyens pour éviter une utilisation abusive de ce brevet. Ça revient justement pour un office des brevets d'invention, en quelque sorte, à définir de façon précise et claire ce qui mérite d'être breveté et ce qui ne mérite pas d'être breveté. Donc là, ces zones, si vous voulez, vertes et rouges, doivent être claires aux yeux des offices de propriété industrielle et des examinateurs des offices de propriété industrielle. Bien évidemment, également, il faut définir la limite. L'idéal, c'est d'avoir une limite franche, une ligne, mais dans un monde réel, c'est différent. Donc, on peut parler d'une zone d'incertitude, une zone de flou. Parfois, c'est un flou juridique, parfois, c'est un flou, comme l'ont mentionné un certain nombre d'experts, qui est lié à l'incompétence, à la non-maîtrise d'un certain nombre de concepts, etc. Et le rôle, justement, de l'Office de propriété industrielle, en l'occurrence l'OMPIC, c'est de pouvoir tracer des périmètres clairs de ces zones et de réduire la zone d'incertitude. Alors l'OMPIC, justement, soucieux de ces questions-là, il a fait sa propre démarche, si vous voulez, pour arriver à ses objectifs, pour répondre à ces questions. L'approche de l'OMPIC s'est articulée sur les trois, si vous voulez, éléments que vous voyez. Première action, c'est d'essayer de moderniser le système national des brevets. Deuxième action, c'est de renforcer les capacités d'examen à l'OMPIC. Et puis, troisième élément intéressant, c'est la transparence dans les démarches administratives, etc. et le partage d'informations dont l'OMPIC dispose. D'accord. Alors, parlons du premier point, qui est la modernisation du système national des brevets. Donc, l'évolution, si vous voulez, du système des brevets au Maroc est passée par un processus, si vous voulez. La première loi sur les brevets date depuis 1916. D'ailleurs, l'année dernière, on a fêté le centenaire de la propriété industrielle au Maroc. Puis un événement important, on en parle depuis le début de ce séminaire, c'est l'adhésion du Maroc à l'organisation mondiale du commerce, et puis l'obligation, c'est-à-dire comme tous les autres pays, d'aligner sa législation au standard minimal. C'était en 1995. Alors la phase 2, c'est la création de l'OMPIC en tant qu'établissement public autonome. Donc ça, c'est très important parce qu'on est un établissement public qui a la personnalité morale et l'autonomie financière. Et ça nous donne, on est sous tutelle du ministère du Commerce et de l'Industrie, on a un conseil d'administration, mais on a si vous voulez, rapidité, efficacité dans l'action. La troisième phase, c'est l'entrée en vigueur de la loi 1797. C'était en décembre 2004. Et puis, il y avait la signature de l'accord de libre-échange avec les États-Unis d'Amérique qui a donné lieu à une révision de la loi marocaine qui est entrée en vigueur en 2006. Et puis, une troisième révision, ça me rappelle un peu l'expérience de l'Inde. On a eu pas mal de révisions de la loi dans un laps de temps qui était un peu court. Donc, la phase 4 le mois décembre 2014 a connu l'entrée en vigueur de la loi 2313 qui modifie et complète la loi 1797. Et si vous voulez, la phase 4, on peut la qualifier pour moi, en tant que chef de département des brevets, que c'était la réforme en quelque sorte historique du système des brevets au Maroc. Alors ce qu'on peut constater, c'est qu'il a fallu 100 ans pour faire, pratiquement 100 ans pour faire la première révision de la loi marocaine, mais il a fallu 10 ans pour faire quand même 3 révisions. Donc ça veut dire que ces aspects concernant la propriété industrielle commencent à avoir l'intérêt auprès des décideurs, etc. Alors, c'est quoi les caractéristiques du nouveau système des brevets? Donc, premièrement, et l'élément central de cette réforme, c'est le fait que l'OMPIC a la prérogative d'examen. Et ce qui est traduit en quelque sorte par l'établissement de ce qu'on appelle un rapport de recherche et opinion sur la brevetabilité. Ça, c'est l'élément central et ça, l'élément par quoi on commence l'examen au niveau de l'OMPIC. Après, le déposant, il a la possibilité, bien évidemment, de réagir, de modifier ses revendications ou ramener des observations. La demande, à ce moment-là, avec le rapport de recherche, sera publiée au bout de 18 mois. Et puis, il a la possibilité, dans un délai de 2 mois à partir de cette publication, des observations, le cas échéant. Et sur cette base, un brevet sera délivré ou la demande sera rejetée. J'aimerais juste signaler que, je vais vous donner un chiffre. Le taux de rejet, après avoir mis en place ce système d'examen, le taux de rejet des demandes de brevets à l'OMPIC avoisine les 55%. Donc on était dans un système à enregistrement où tout passe, tout était sanctionné par un brevet, et on est dans un système à examen où quand même il y a un filtre qui est assez important. Alors je passe... Alors justement, avant la réforme de 2014, je vous donne cet exemple. C'est une demande marocaine qui a été, pour laquelle un brevet a été délivré en 2009, qui contient, alors c'est dans le domaine pharmaceutique, je ne vais pas entrer dans le détail, mais il s'agit d'une forme, d'une composition pharmaceutique sous forme de capsule. La version marocaine du brevet contient 21 revendications et avec vraiment une étendue de protection qui est très large. On voit ici qu'on a une formule chimique avec des radicaux et chaque radical, c'est une famille large de produits, etc. Alors ça, c'est la version qui a été délivrée dans l'ancienne loi, si vous voulez. Et ça, à côté, à droite, c'est quand même le nombre de familles européens qui contient moins de nombre de revendications, seulement 13, et vraiment avec une revendication qui concerne le produit objet du brevet, inventé, si vous voulez. On est vraiment dans un scope qui est très réduit. Et puis, cette même demande qui est délivrée avec une étendue étroite, elle a fait l'objet d'une opposition qui est en cours. Ça, à l'Office européen des brevets. Ça, je parle du système qu'on avait avant. Alors, après l'entrée en vigueur de cette réforme, je peux vous donner cet exemple. Il s'agit de, justement, le fameux Sofos-Buvure. C'est une demande marocaine qui a été déposée récemment, je pense en 2014. Et ça, c'est un extrait, ce que vous voyez ici, c'est un extrait du rapport d'examen fait par l'examinateur marocain, dans lequel il dit que la quasi-totalité des revendications manquent d'activité inventive. Donc pour nous, d'ailleurs ça a été dit dans l'intervention de Mme Gaïl, on ne donne pas de brevet pour des innovations mineures. Et ça, c'est un cas parlant. Ça, la majorité des revendications ne sont pas inventives et il y a des revendications qui ont été rejetées parce qu'il s'agit de méthodes de traitement thérapeutique. Troisième exemple également, c'est toujours une revendication avec une étendue très large, c'est une revendication genre Marcus, et qui a été rejetée par manque d'activité inventive, parce que justement, il n'y a pas l'effet thérapeutique n'a pas été démontré pour toute l'étendue revendiquée. On parle de suffisance de description, etc. Et nos examinateurs, ils sont capables, à l'heure actuelle, d'aller dans cette profondeur, si vous voulez, en termes d'examen. Alors, si on voit l'autre aspect qui est la balance, on a un certain nombre de dispositions légales qui un peu reprennent ce qu'on a... Oui, je suis conscient. Vous pouvez me donner une minute de plus? Non. Donc, on parle des dispositions de Bollard, elles sont dans notre loi. On parle de la flexibilité, c'est-à-dire de ce qu'on a dit, l'épuisement des droits, etc., les licences obligatoires, et même la possibilité d'exporter dans des pays qui n'ont pas la capacité de production, etc., etc. Ça, voilà. Il y a le renforcement des capacités. Nous sommes 20 examinateurs. En 2008, on était 3 examinateurs. Actuellement, on est 20 examinateurs. Et dans le domaine de pharmaceutique, on a, dans le cluster pharmaceutique, on a 6, dont 4 pharmaciens, docteurs pharmaciens. Et bien évidemment, on a accès à des outils de recherche performants, EPOCnet, entre autres, etc. Voilà. Et puis, le troisième point, c'est le partage d'informations. C'est très important. L'OMPIC met à la disposition du public un certain nombre de plateformes où sont disponibles toutes les informations qui peuvent être utilisées pour votre cause. Voilà. Merci de votre attention. Je suis désolé de consommer plus de temps.
Thanks a lot. I forgot that here is 3 people who know at least billion details each. So be careful when you will ask a question later. So the next speaker, Manati Ala El Khatami from Egypt. Mana is a pharmaceutical patent examiner at the Egyptian Patent Office and an intellectual property trainer at the National IP Academy of Egypt. She is also one of IP experts on VIPA, Experts Database. She received her degree from Ain Shams University with a baccalaureate degree in pharmaceutical science in 2008. She obtained a postgraduate diploma in intellectual property rights from the Regional Institute of Intellectual Property Facility of Law, Helmand University.
Actually, Mr. Adel, President of the Patent Office, was supposed to be the speaker today, but he had some emergencies, so he wasn't able to make it, so I'm the speaker. I have his presentation, but it has too many information, which you can get it later, so I'm not going to go through all the slides, just some of them. And I prefer to make it a speech from the heart about what we do actually at the Patent Office, being a patent examiner here. So, first, let's go. The Egyptian Patent Office is under Ministry of Higher Education and Scientific Research. It has many departments, anyone can know them. What we do at the Egyptian Patent Office, what is our approach? We do the legalizations, the IP law. We have administrative system to apply the law, and we should make the information, the IP information available, and we also encourage and support inventors. How we do that? For the legalization, the root of IP in Egypt is since 1949. We used not to protect the chemical entities, and the term of protection was just for 10 years and 15 years. Then after signing the TRIPS agreement, we have to amend our law to include these things. We have to make pharmaceutical compounds patentable. So, lucky Egypt, our policymakers were familiar with the consequences of implementing the TRIPS agreement and amending the law. So they applied all the flexibilities of the TRIPS agreement in that amended law. So, like, no need for that one, no need for that one too. Sorry. Okay. I won't go through all the flexibilities. We pointed them out in many of the presentations today, but like Article 1, we have the patentability criteria. It has to be novel and inventive, and being industrially applicable. There have to be unit of invention. Disclosure, we apply the best mood. not just enough disclosure. We have many criteria for exception from patentability, and we have polar exceptions, parallel importation, an article for protecting the traditional knowledge. We have the Ministry of Health. It has to look for the patent before granting it. Compulsory licensing, expropriation, invalidation, or revoke. Also, after the examiner do his report, it has to go for revision by a senior examiner, and then we have the director of the patent examinations and the general director. All of them has to have a look at the report before sending it to the applicant. Some kind of quality management for the report. No need for this now. We had a look at the law, a quick look at the law. Then let's talk about the administration system. We currently are working on the development of the Egyptian Patent Office. In 2005, we started to open the mailbox, and patent examiners started to examine the patent application for pharmaceuticals. Actually, there was no experience. There was lack of databases and lack of information. So we used to depend on other offices' reports and used to grant patent if it is granted in EPO or US. Later on, the office started to give trainings for examiners. No need for, sorry. I told you I'll skip some. The human resource. We start to give training to patent examiners on how to examine the pharmaceutical patents and how to apply the patentability criteria and what is novelty, what is inventive step, and how to apply it. And there was reallocation of the examiners. We applied many pharmaceutical examiners. Actually, we have 113 patent examiners. 20 of them are just for the pharmaceuticals. So no need for that. Like Tahir said, there is a conflict that patent examiners have the technical knowledge, they know nothing about the law. The case is different in Egypt. Actually, most of the examiners took an IP diploma for the IP law, and we are very familiar with the law. Actually, we have some argument with the legal department why you mentioned the articles in your technical report. We said it has to be complete. So we have the legal knowledge. Okay, it's here. It's around 55 of the examiners already took the IP diploma. Others have masters in IP and other fields of technology. So this is our experts. Okay, again, no need for the office procedure. I just talk. Okay, this is the speech from the heart I'm going to talk about. What we do in the patent office. After having our trainings or how to apply the inventive step, we were lucky to being trained by academics and by other people who have that concept that we need to apply the balance between the public interest and the private rights. It's not about just granting a patent or refusing it. Your work matters. What you do affects other people's lives. So there is no written guidelines for that, but this is adopted internal policy between us as pharmaceutical patent examiners. We have to be very critical when examining the patents. You have to adapt the very high standards of examination. For novelty, it's clear. If it is written in the prior art, then it is not novel. So there is no arguments about it. But for applying the inventive step, we never we never grant patents for minor modifications. We had this internal policy for crystalline forms and for salts and for enantiomers and for this minor modifications, which any person which has the technical knowledge can just do it. We never grant patents unless in very rare cases where the applicants submit like studies proving there is unexpected modification in the activities. That's why we have to grant it in this case. Otherwise, we never do so. We take trainings in different countries. Me, myself, I got a training in the JPO, Japan Patent Office, and in the Korean Patent Office. Some of my colleagues went to US and EPO. We have many trainings by WIPO and EPO Online Academy. Okay. So when I was in Japan, we went to a big pharma company. They told us about their IP procedures and what they do. So they start telling that once they had a chemical entity which has a predictable good activity, they start for applying a patent to get a date of priority. Then they have further research work to do on that entity. Then they get the exact compound which have the good activity. Then they apply for a second selection patent. And then they start working on it, doing a salt, doing a pharmaceutical composition, doing different forms of pharmaceutical composition, and they clearly identify that they do so to prolong the time of exclusivity or monopoly. So actually, going there and seeing what they do in real practice make us more aware what we do is right. You have to be very strict. This is not modification. This doesn't deserve to be patented. They are just having an evergreening. Also, when I went to Korea, it was a course actually about IP management. I was being educated how to prolong the patentability period. This is not applicable being a patent examiner, but actually this is what pharma do. They start using old entities, trying to give a second use just to prolong the patentability period. So this makes us more aware and more critical about examining such patents. Actually, we sometimes have patents with a very broad scope of compounds and substitutions, and yeah, we ask him to narrow it down, narrow it down, narrow it down. Finally, we can get just one compound. After about 100 and more claims, we get one compound to be patented, and finally, we can reject even that one compound. Okay, so I don't want to take it long, but I'll give an example for Sofosbuvir. Actually, Sofosbuvir was rejected in Egypt, as it is all of you know that. Lucky Egypt, the Sofosbuvir wasn't. It has many applications. It's the WOP application is 2008, which was applied in Egypt, not the ones before. So we took the prior applications against it. Then he started arguing it is a certain enantiomer, not the same published before. So we argued that it is known that every compound has 2 enantiomers, so it is easy to predict it, so it is not inventive. So I don't want to go through more. Can I take 1 more minute? Just 1. Okay. 1 minute. It's the same. Okay. Just for the patent office procedures, we went from paperwork to electronic system. We're mixing the electronic system with the paperwork. We are not actually fully automated now. And this is the pathway for the application in the patent office. You can look at it later, not important now. We have an electronic application system. Actually, this is not for the applicant, it is for the focal points. They can apply to the patent office. Here it is. We have focal points in many research centers, in universities, and factories, and industrial new cities. An applicant can go to these focal points, and they apply online to the patent office. For the availability of IP information, we have our own website. We have a large collection of application. We have online access to ABIA, because this is not important. This is for us as patent examiner. We have many free databases to use, and we have like paid databases we are applied for to make us more critical on applying the patent. Examining the patent. This is not important. Okay, for encouraging innovation, we have to encourage our local innovators. So we have regional training centers. We have IP Academy. Actually, I'm one of the trainers for the IP Academy. We spread awareness of IP, and we are trying to spread our orientation about that balance between the public interest and the private rights. It's not just about patenting or just about protection. There has to be a balance. There's also the TICO offices and the consultation services. This is the TICO office and the organizations under it. You can easily find it. And in terms of supporting innovation, okay, I'm done. Just repeat it by name. In terms of supporting national innovators, there is the Egyptian Young Academy of Science, the School Student Innovation, the Fab Lab project, INTILAC, I'm done. The Egyptian Knowledge and Technology Alliance, this is the Cairo International Exhibition for Innovation. Okay, I'm done. This is some statistics, not important. You can just, you can just know them. Thank you.
Thank you. So the second person who have a really big presentation. So the third one, Georgina Gerde. She is a lawyer who specialized on intellectual property for the past 20 years. She teaches intellectual property at 2 universities, and now she works as a chief patent legal officer at the Argentine Patent Office for the past 20 years. So please.
Bueno, buenas tardes a todos. As well as Germán, although my presentation is in English, I prefer to speak in Spanish, if that's possible. Yes? Perfect. Bueno, como hoy ya tuve una intervención, una pregunta que después me gustaría aclarar porque no sé si fue muy bien entendida. Antes que nada, quería agradecer muchísimo la invitación, poder estar acá y aprender de todos ustedes, porque lo que uno vive a diario dentro de la oficina de patentes, dentro de lo que son las organizaciones internacionales o las negociaciones internacionales, muchas veces no ve del todo la otra cara, que es la que muestran ustedes con casos concretos. Y la verdad que es importantísimo escucharlos a todos ustedes juntos. Y lo que dijeron algunos expositores esta mañana, que es importantísimo que ustedes se unan y tengan todos una posición única y muy fuerte, porque a veces al ser muchas posiciones es como que quedan como, a uno no le queda que es algo muy concreto, sino que son muchas aunque repitan lo mismo. Bueno, durante 20 años yo vi la evolución en muchas cosas. Yo entré a la oficina cuando se hablaba de los derechos exclusivos de comercialización, que muchos de ustedes ni siquiera han oído hablar. Pero bueno, fui convocada acá para hablarle de la Oficina de Patentes Argentina. Y como todos saben, Argentina adoptó guías de patentabilidad en materia química farmacéutica. ¿Y cuál es la base de todo esto? Bueno, creo que todos los que estamos acá sabemos que el TRIPS tiene flexibilidades, que el TRIPS establece requisitos de patentabilidad y cómo aplique cada oficina esos requisitos de patentabilidad van a ser los criterios. Cada país va a tener sus propios criterios y tiene que haber una coherencia a nivel político. Esta fue la base de todo. Creo que el Estado argentino fue coherente, fue consciente de que este tema era una política de Estado y que no lo podía dejar librado ni al Ministerio de Salud, ni al Ministerio de Comercio o Industria, ni al Instituto Nacional de Propiedad Industrial. Se dio cuenta que el tema de patentes era transversal a un montón de ministerios y a un montón de institutos y que iba mucho más allá conceder una patente de cualquiera de estos 3 organismos que les acabo de nombrar. Entendió que debíamos tener estrictos criterios de patentabilidad, una interpretación muy estricta y que no hubiera grises en qué era, o sea, qué se podía conceder y qué no, y que tuviéramos altos estándares. A mí me gustaría retomar un poco lo que dijo Germán hace un rato. Él dijo, el TRIPS tiene flexibilidades. La primera gran flexibilidad que yo siempre destaqué es que no define qué es invención. Y la Argentina ya en el 2003 definió, o sea, más allá de que la tiene definida en la ley como creación humana, hizo uso de esta gran flexibilidad en todo lo que es el tema biotecnológico. Entonces, cuando cada país define qué es invención, y nuestra ley lo definió como que es una creación humana, todo lo que era un descubrimiento automáticamente quedó afuera. Y después fuimos en cada uno de los requisitos de patentabilidad. Pero las guías químico-farmacéuticas dejan mucho afuera por esto, porque con la definición de invención, mucho de lo que se pretende patentar en el campo químico-farmacéutico son descubrimientos, no fueron creados por el hombre. Entonces, la primera pregunta que uno se hace es, ¿esto que se pretende patentar fue creado o no por el hombre? Si la pregunta es no, ya estamos. Esto no va a ser patentable en la República Argentina. Bueno, dicho esto, que tiene que ser primero que los estados tomen conciencia de que es una política de Estado y que es transversal a muchos ministerios, se aprobaron las guías en el año 2012. Fue una resolución conjunta del Ministerio de Salud, del Ministerio de Industria y del Instituto Nacional de la Propiedad Industrial. ¿Qué fueron estas guías? Estas guías yo creo que son aún más estrictas que las de India, que los criterios de India, y que son más estrictas que las que escribió Carlos Correa con la OMC, porque las escritas dejan cierto margen de maniobra. Quiero decirles que las guías de patentabilidad que aplica hoy la República Argentina casi no dejan margen de maniobra. Es muy difícil encontrarle un gris. Si yo puedo tener 30 examinadores, cualquiera de mis examinadores que estudie la misma solicitud va a llegar a la misma conclusión, porque las guías casi no dejan márgenes. Y ahí se terminan los grises. O sea, y eso es por una fuerte política de Estado que no fue fácil. Yo acá les cuento el resultado de la parte linda, tal vez les estoy diciendo, pero no fue fácil. Y yo hoy cuando hice mi intervención dije que era muy importante formar o educar, porque cuando llegaban las personas que tenían que establecer la política de Estado o tomar medidas, había un gran desconocimiento. Pero formar y educar va también mucho más allá. Nosotros siempre quisimos formar y educar a los examinadores nuestros. Ellos pueden ir a cualquier oficina a escuchar cursos y aprender, pero nosotros queremos que ellos tengan un criterio y una independencia de criterio. Buenos examinadores que sean muy lógicos, muy criteriosos y que puedan aplicar independientemente de lo que haga otra oficina, es valiosísimo. Y eso también forma parte de educar, no solamente a la sociedad, o sea, porque si ustedes no los educan, otros los van a educar por ustedes. Entonces es muy importante ser consciente de esto, que la educación termina siendo la base de todo. Si no lo hacen ustedes, otros lo van a hacer. Entonces yo voy a educar para que después esa persona pueda tomar las decisiones usando su criterio. Entonces ya no me va a preocupar si va a tomar un curso en Estados Unidos o en Europa, porque yo sé que tiene, o sea, que tiene el criterio como para aplicar lo que haya que aplicar, ¿sí? Bueno, ya que tengo poco tiempo, estas guías establecen, por ejemplo, que los nuevos usos, las nuevas formas, las nuevas formulaciones de patentes y cambios de drogas no son patentables. Ahora voy a ir específicamente a cada uno de los puntos. La verdad es que si alguno quiere las guías completas, se las hago llegar en castellano o en inglés. No me quiero extender, prefiero que el tiempo lo usemos en preguntas. Para ir, por ejemplo, los polimorfos no son una creación humana, los pseudopolimorfos estamos en el mismo sentido, los enantiómeros tampoco son patentables, las fórmulas Marcus tampoco, o sea, tiene que estar exactamente todo descrito en la descripción, todo detallado. Después hablamos de selecciones, de las solicitudes de patentes, de sales, de metabolitos activos y todos los puntos que ustedes ven acá, donde se hace todo un análisis de cada uno de los puntos y se dice al técnico qué se entiende por qué eso no reuniría los requisitos de patentabilidad o qué debería tener para reunirlos. Si bien, como dijo Germán, fuimos cuestionados respecto a estas guías, la respuesta de Argentina siempre fue: todos los países tienen guías de patentamiento, Argentina las tiene desde el 2003, estas desde el 2012, y nosotros mediante estas guías no estamos estableciendo nuevos requisitos de patentabilidad, no son nuevos requisitos, sino son criterios que les dicen al examinador, lo instruyen de cómo aplicar los requisitos. Todo requisito del TRIPS, por flexibilidad, te deja a cada país establecer criterios. Al no ser normas jurídicas, no creamos nuevas normas, o sea, no pueden ser cuestionados a nivel de la OMC ni de la OMPI. Si bien tenemos juicios, la verdad que estamos muy tranquilos respecto a que cuando uno estudia los motivos por los cuales se dictan estas medidas y habla de las flexibilidades del TRIPS, somos muy solventes en por qué sí Argentina podía dictar unas guías de patentamiento en este sentido. Y todos los alegatos de abogados que vienen en el otro sentido, la verdad es que no son solo contestados por los técnicos, sino la parte legal siempre es contestada por abogados especializados. Con lo cual, si de alguna manera se quiere confundir a los técnicos con terminología legal, yo creo que eso directamente los expedientes pasan todo lo que es temas legales a la parte legal que los contesta, para tener la mejor postura por si esas solicitudes llegan a enfrentar un juicio posterior y una unidad de criterio. Y por el otro lado, todo el cuestionamiento que tuvimos a nivel judicial, siempre el Ministerio de Salud, el Ministerio de Industria y el INPI actuamos en conjunto. Todos nos sentamos, debatimos, siempre somos los mismos, ¿no? Porque este mundo es chico, pero siempre se trata de tener un criterio común, un debate amplio y que cada expediente esté resuelto de la mejor manera posible por si tiene que enfrentar el día de mañana la justicia, que es muy importante que no lo dé vuelta, o sea, que no nos obligue a conceder una patente. Esto es todo lo que tengo que decir. Bueno, algo más puedo aclarar es que unas muy buenas guidelines con unas muy buenas, nosotros tenemos un sistema de observaciones de terceros previo a la concesión de patentes. Si uno tiene unas muy buenas guidelines de patentamiento, más muy buenas oposiciones que presenten los terceros, que no me presente el search report hecho por otra oficina, sino documentos científicos, o a veces hacen estudios de rayos de difracción para probar que es lo mismo lo que quieren patentar que otra cosa, a lo único que me va a conducir va a ser a patentes de altísima calidad. Entonces, guidelines más buenas opposition lleva a patentes de alta calidad, una política de Estado en la materia, y cualquier cosa que lleve a armonizar los requisitos de patentabilidad. Todos sabemos, y creo que ustedes más que nadie, que un modelo, como one size doesn't fit all, que se suele decir, no le va a todo, así que todas las políticas en materia de propiedad intelectual tienen que ir de acuerdo a cada país. Muchas gracias y estoy a su disposición para lo que necesiten.
Thank you. And the last presentation of this day is the civil society representatives. So from Chalermsak, Kittitrakul. He began his career on IP and access to medicines at in 2003, but now he works with AIDS Access Foundation and continues monitoring policies affecting access to medicine, including a lot of negotiation. So the short presentation.
Okay. Yes. I would like to thank you, ITPC, first for inviting me to join this conference and give me a chance to talk about the story of Thailand, how we're working on the IP and access to medicine. Firstly, I would like to give you the overview background of how bad the situation is in Thailand regarding about evergreen patent. This data, this information comes from a study that is done by an independent academic, and they get the support from the FDA and also the IP office to access to that information. This is the information that we go back about 10 years from 1999 to 2010 to look at the patent application and also the patent has been granted at that time, and to look at it, what is the evergreen patent or not? And based on the information, we have seen that we have a very serious problem in Thailand regarding about evergreen patent. And we have seen the loss of the evergreen patent have been granted on the use claim and compositions, and also even Markush. That is the most evergreen patent that we found in Thailand. And based on this, the information we have found as well during that 10 years, and about the 2,000 applications that filed with the IP office, 84% of the patent applications on medicine is considered as the evergreen patent. And for the patent has been granted, 72% of them is considered as the evergreen patent. And based on this information as well, we have lost a lot of money that we have to not supposed to spend on those medicine, and we have loss of the more than about 8,500 million baht for those medicine, and it's covered about 95 items in that 10 years. So this is why Thailand has to pay a lot of money, particularly the government, that for the medicine that we have prescribed to our patients. That the situation has happened in the last 10 years. And out of this, it's come to consultation between civil society, academic, and also IP office, and over the FDA, that how we can solve this problem to reduce the number of evergreen patents in Thailand. And we have several rounds of the meeting with all the stakeholders, including the big pharma as well, to develop the guideline to prevent evergreen patent. Then we had the guideline and we used them for 5 years. Then anyway, based on the guidelines, not that good as the Indian treaty or even the guidelines of the Argentina, and have a lot of gaps, lots of the interpretation on those guidelines, particularly about Marcus claim and about the polymorph, something like that. Still have problem in that guideline. And this is an example that how the evergreen patent happened in Thailand. We raised an example of the artesanal, that's the ARV in Thailand. At the time that they did the study, they found only 3 applications that in the IP system, and one of them has been expired. But I just, before coming here, I had to look at the database back again, and we found 6 more applications that find on the same medicine. This is quite a very usual tactic that the big pharma use all the time. Just only one medicine, but have a lot of the application on one medicine. And they try to prolong or extend the protection more than 20 years from the original or the very primary patent supposed to be protected. And out of this 9 applications, it cover the patent protection to 33 years instead of the 20 years. And in terms of the medicine, because Thailand have the universal health coverage scheme, and the government subsidize the medicines expense for the people in Thailand. Based on this one, because of they had patented in Thailand, we have to buy the original version of the artesanal, and we had to pay a lot of money on that. But if you look at the generic version on the same medicine that sell in India, it's much more expensive than that. So it means that why Thailand has to lose the huge amount of money for the unlimited patent that given on artesanal. And this is an example on the evergreen patent that filed on artesanal. And I would like to mention another problem that we have found, because we, civil society, we try to make use of the IP law to promote access to medicine. And we try to find the peak and opposition from a certain number of the medicine in Thailand. And we have many gaps, many flaws in our patent law. And from this one is the process how the IP office to consider or examine to give the patent. And we have find that the first one is like we have no time limit from the filing date until the publication. And just have no time. Sometimes they take 5 years, 6 years, but the protection start already on the filing date. And the second weak point of our law is they have the very limited time to file the pre-grant opposition, just up to 90 days to file it after they had the publication. That's another problem that we have found, and it's a big challenge for us as well, how to file the pre-grant opposition in time. And by the Thai law, we don't have the post-grant opposition that make it worse. And before than that, we can file the third-party observation to the patent office. But in our law, it's mentioned that it depends on the decision of the head of the IP office that going to make use of our information to be considered to give or not to give the patent to that medicine. That's another barrier. And the last one, if it is granted, we have to file the lawsuits to withdraw it. So that's very time-consuming process, actually, how to wait until decision comes from the court to make about patent on that medicine. So this is another kind of barrier that prevents us to make use of our law to promote access to medicine. And based on our experience, we have seen a lot of challenges happening. About firstly, it's about the vagueness or the ambiguous of the patentability criteria in our law. Even we had the guideline, but still have needs a lot of interpretation. And secondly, we have a very short the pre-grant opposition period, 90 days, and we have no post-grant opposition and no time limit before the application as well. Mm-hmm. And also in terms of the examination process, we have the lengthy period before that. It requires 5 years. So it's like a keep it for free for the protection. And they have to do nothing. They don't have to submit any document to the IP at all. And in terms of database of the patent in Thailand is problematic as well, because it's not easy at all to access those information. But right now, they try to, develop the online system, but it's still on the process. So we miss so many chances, to find that information and find the precant opposition in time because, information is not available. Or even it's available, accuracy is a problem as well. Sometimes it's not the same medicine that we are trying to find the precant opposition. And I think the last one is quite the most challenge because it depends on the attitude of the patent examiner or even the IP policymaker. They're thinking about to protect the benefits of the patent holder or applicant more than the public interest. So this is the way we try to dialogue with them over and over that about Doha Declaration, but to put the people interest before the trade, but it still doesn't work well. But anyway, on the right-hand side is the picture that we try to oppose an initiative of the military government. They want to use the Prime Minister executive order to solve the backlog, the patent examination, because I have about 20,000 applications is still pending. And in that is about 3,000 is related to pharmaceutical. So we try to raise the example of the situation of ever gaining in Thailand. If you speed it up, to address this kind of issue is going to let go the unmerited patent and going to make the situation worse. For we try to oppose that, even try to intervene their meeting, or even to try to the global campaign to get the supporting signature from 19 countries and from the 46 organizations to help to have the letter to the government. And this is the day that we submit the letter to the government that friends from the international organization disagree with this idea to speed it up, the examination process. And based on this, we have seen both opportunity and risk at the same time. After we have done for 2 years trying to find the precant opposition with the Thai IP office, they have some change happening. The first one, they have recruitment of new patent examiner from 4 person to be 200 person. But our concern is what kind of training going to train these people? And it's the perspective of the protection of health of people is going to include that or not. That's the question. And the second one, they try to improve the online system to make the database more the friendly user or more easier to access. And but anyway, we had the question about how good they're going to do that. And they had created cooperation between the FDA and the IP office as well to have the link database on both two organizations. It means that if you go to the database of the FDA, you can find that medicine have any patent in that. Or even to look at the database of the IPS, you're going to link together. But it's still on the process, really beginning process. And the next one I would like to mention, because we have been make use of UN high-level panel, the report on that, and try to make use of the good part of that, because they mentioned about what kind of patentability is supposed to be. That's the first one. And the second one, we are now in the ongoing process to amend our patent law. And also, together with that, also to have the DAX law as well. That's been amended. I have to make use of this one to voice our concern, how to make our patent to promote access to medicine. And in terms of DAX law, we have to propose the proposal in terms of we have to submit the patent status and also the pricing structure as well when you have to file registration with the FDA. But anyway, in this kind of public hearing have got a retaliation from the big pharma as well, because they try to block our this kind of proposal that we submit. And last but not least is an ongoing process of the negotiation on RCEP, and also the EU-Thailand FTA that's going to bring back to table again, that's going to introduce the TRIPS plus the provisions. And in the picture, you can see that this is a group of people living with HIV/AIDS that they try to find the first precant opposition to the patent office on the Ractacovir. That is a key that antiretroviral medicine to the IP office, and I'm still in the process how to accept our opposition or not. So because of the time limit, I have to stop my presentation over here. Thank you.
Thanks a lot. So it was really fast speaking. So I'm happy to say that we can skip our dinner and have a great conversation now. So unfortunately, it's a joke, and we have only already two questions. So please use the mics. Who is the quickest one? just two questions. So, please.
Je voudrais poser une question à l'OMPIC. En français. English. French. Ok. Est-ce que l'autonomie financière veut dire que l'Office est essentiellement financé par les redevances des brevets? Et est-ce qu'il n'y a pas de conflit d'intérêt dans ce cas? Et plus l'OMPIC délivre de brevets, plus il dispose de ressources. Et enfin, la dernière question, est-ce que vos examinateurs sont formés sur les enjeux de santé publique et de propriété intellectuelle? Merci.
Yeah, I translate briefly in English. La question c'est pour l'OMPIC, c'est ça? So the question is for the Moroccan Patent Office. The question is if the office is financially independent, does it mean that the only resource is patent application redevance, I don't know how to say it in English, fees? And in this case, is there a conflict of interest because the patent has interest to grant more patents to get more resources, and the other part are your patent examiners, now that Morocco is doing examination, trained on IP and public health?
Je réponds en français. Et vous assurez la traduction également. Effectivement, nous sommes autofinancés, donc c'est justement ce qu'on perçoit comme droit exigible par rapport au dépôt de brevets, mais non seulement le dépôt de brevets, nous sommes un office de propriété industrielle, donc il y a les marques, on est également, on gère tout ce qui est certificats négatifs, donc, etc. Donc nos recettes proviennent de plusieurs sources, y compris bien évidemment les brevets, mais comme j'ai dit tout à l'heure, et ça je pense répond à votre question, on a quand même quelque chose comme 55% de demandes qui sont rejetées. Si on était justement dans cette situation de conflit d'intérêts et si on cherche à vraiment délivrer plus de brevets, on serait dans des taux de délivrance un peu plus importants.
I need to translate, otherwise I will forget. Yeah, he confirmed that, yes, they are independent, so they have the fees of the patents, but not only the patents, so they also do trademark, they do patent searches or brands, etc., and research, etc. So they have different sources, and it's not only about patents. And there isn't really a conflict of interest because they have a rate of rejection of 55% of patent applications, so they don't grant patents just for the fees.
Nous avons nos propres directives qui un peu précisent comment nos examinateurs font l'examen. Et juste à titre d'indication, parmi nous, il y a un collègue qui est examinateur dans le domaine des produits pharmaceutiques. Et lui, justement, il est allé s'inspirer des directives dont les collègues ont parlé, les directives de l'OMS en matière de... etc. Donc, ils sont sensibles à cette question.
Yes, the patent examiners have seen what is practices in other patent offices, including what WHO is recommending, and they have are they trained on IP? Do you have and you no, sorry, I forgot. And you have guidelines as well on patent examination. Are these guidelines public? Or internal?
A part of the guidelines.
Okay, thank you.
Are public.
And second question from Pascal. She's running.
Thank you. I just wanted to ask a question to the representative of Morocco and Argentina. In recent years, the OMPIC signed an agreement with the European Patent Office, and the result of that is that as 2015, if I'm correct, patents granted by the European Patent Office can be validated in Morocco. I would like to ask you what will be the consequence of this, in particular regarding your right to reject some application. And I also heard that Argentina signed this highway prosecution. Yeah, can you explain what will be the consequence of this process as well? Thank you.
Justement, le système de validation entre le Maroc et l'Organisation européenne des brevets est entré en vigueur en mars 2015. Et pour nous,
can we do one sentence by sentence, because the agreement, well, for the audience, Pascal, you speak French, but for the audience, yes, there is an agreement of validation of patents between the
patent
EPU.
prosecution highway.
Yeah.
It's not a validation. I think that is a misunderstanding.
Well, is it? No, we know what we are.
It's not the same thing. It's not the same thing. We have PPH, for example, with Spain, but we have a validation system with the European Patent Office. And we did, le système de validation pour nous n'était pas une fin en soi. Le système de validation pour nous était un élément qui allait nous aider à mettre en place notre système d'examen et que nos examinateurs se focalisent sur l'innovation locale. Parce qu'on ne peut pas recruter un nombre énorme d'examinateurs. Et puis, si on va vraiment un peu s'amuser, si vous voulez, à réexaminer des demandes, par exemple PCT, qui ont été examinées une première fois, une deuxième fois, etc., on va un peu dépenser nos énergies sur refaire des choses qui ont été faites.
So the answer is that the objective for Morocco to do the agreement with the with the European Patent Office was not mainly to validate patents or to rely on validation, but to improve the examination process in Morocco. And instead of re-examining several times applications that have been examined by other patent offices, so they can benefit from this information to inform their decisions. I'm not really convinced that this helps patent examination to rely on European examination. But
c'est la traduction de ce que j'ai dit ou c'est votre?
No, this is my comment. Okay. So let's go maybe to another question and we can have a discussion on dinner.
Bueno, respecto a tu pregunta, sí, Argentina suscribió PPHs, pero el PPH se firma a nivel del presidente del INPI, con lo cual mismo los PPH, si uno los lee atentamente, lo dicen, nunca podría ir por encima de lo que son las guías de patentabilidad químico-farmacéuticas que están firmadas a nivel ministros. O sea, en realidad los PPH te aceleran si una solicitud se iba a estudiar, por decir algo, en el puesto 520. Oh, okay. The translation. Okay. Yes, we signed PPH, but you know, this does not relax the guidelines criteria, because the president signs the PPH, the INPI's president, but the guidelines were signed by the ministers. So each patent, each application, it will be studied under the guidelines that I told you before. They have a higher level, a legally higher level. The only thing that changed is if an application will study in, for example, in a year and a half, now perhaps it will study in 20 days. But before, you will start studying the application, not finished, you know. But as you see, all our experience is we didn't have even one presentation of PPH, because they know that if they present a PPH application on pharmaceutical field, they will be rejected. Yes, because we have to apply the guidelines. So yes, we signed it, but you know, the text of the PPH said that Argentine that doesn't create a legal binding, and Argentine can use the examination from the other office as the way as he wants. So for us, we will study everything.
Thank you. I'm very sorry, but I should close this session because we should be in the lobby at this minute. But fortunately, tomorrow we will have a session on challenging unmerited patents, so it will be a round table at 2 p.m. So please come.